This Microtalk is part of a mini-series on intellectual property ownership. We encourage you to watch the entire mini-series available on Springboard. Thank you.
I'm Spencer Glendy, a partner in Mayor Brown's Salt Lake City office. I'm a member of the firm's technology and IP transactions practice and also its emerging companies and venture capital practice. Much of what I do is focused on tech startups contracts related to the creation, ownership, and commercialization of technology and intellectual property. And I'd like to share some thoughts about a belief or assumption that I often hear from startups when talking about intellectual property ownership. That is, we paid for it, so we own it. This assumption is true only in certain circumstances. To break those down, let's recall that intellectual property protection in the US and most other countries mainly comes in four forms: patents, copyrights, trademark rights, and trade secret rights. And this notion of we paid for it, so we own it, most closely aligns with the concept of a work made for hire under the copyright law. According to US law, if a copyrightable work of authorship qualifies as a work made for hire, then the copyright is automatically owned by the employer or the other entity for whom the work was prepared, as opposed to the individual author. This does sound a lot like we paid for it, so we own it, but it is definitely not that broad or that simple. For one thing, this concept applies only to copyright. To say, for example, that a patentable invention is a work made for hire doesn't really mean anything legally. Also, under the copyright law, there are only two kinds of works that qualify as works made for hire in the first place. First, works prepared by employees within the scope of their employment. So if your actual employee writes code for a particular software application as part of their job, then you as the employer would automatically own the copyright in that code. The second kind of work made for hire is a work that's specially ordered or commissioned for one of 9 particular uses specified in the Copyright Act if the parties have signed a written agreement that the work is to be considered a work made for hire. If a work created by your contractor rather than an employee is not within one of those 9 categories, then it cannot be a work made for hire, even if the contract says it is. And most of those 9 categories are pretty narrow. Things like atlases, translations, tests, and answer materials for tests. Even the categories that sound more general, such as compilations or contributions to a collective work, have pretty specific meanings under the Copyright Act. So be very careful when assessing whether they cover what you're paying a contractor to do. As a side note, commissioning something as a work made for hire does have one potential advantage over a transfer or assignment of copyright, at least for works that are expected to be valuable for several decades, in that US law lets authors terminate copyright transfers 35 years after the work was created. And the only way for a company to avoid that is to own the work from the outset as a work made for hire. But that path can also have some downsides. In particular, if you have a work made for hire contract with someone who resides in California, state statutes will treat that contractor as an employee for purposes of workers' compensation, unemployment, and disability insurance requirements. In other words, be very cautious about relying on the work made for hire concept and assuming that you own IP simply because you paid for its creation if you're talking about anything other than copyrights in works made by employees within the scope of their employment. A contractual assignment is the only way for a company to own the copyright in some works. And even if you're confident that a contractor's work could qualify as a work made for hire, the contractual assignment is often just as good, and in California, perhaps even better than the work made for hire option. To learn more about IP and other topics of interest to startups and their investors, I invite you to visit Mayor Brown's Emerging Companies and Venture Capital portal, Springboard. And thank you for listening.